Hi, I'm attorney Gregory Dell, and I'm here today with attorney Alexander Palamara, and we're going to discuss an interesting topic, Alex, which is this is one of the most popular videos that we do, which is basically how to protect your disability insurance benefits with the Lincoln Financial Insurance Company. And also that goes along the lines with tips for basically how to avoid a Lincoln Financial disability claim denial. And the reason this type of video is so popular is because anyone who's on claim is always nervous constantly about the fact that they're going to be denied. And as you know, one of the unique services that our law firm offers is this monthly claim handling service where we get involved and take over every aspect of the claim. So we'll talk about these tips for how to protect claims and how we work with the claimants to help them, prevent the benefits from being denied. So let's start first with what I think would be the first tip, which is what comes to your mind when dealing with Lincoln Financial as the single most important thing for a claimant to make sure their claim won't get denied?
It's proof. It's your duty as a claimant to prove your claim, and you constantly have to keep on proving your claim to the insurance company. Congratulations on getting approved, but the insurance company, no matter what their commercials say, they don't want to pay you benefits. Each time they're paying you benefits, they're paying you thousands upon thousands of dollars that's leaving their pockets going into your pocket. So they kind of want to deny your claim, but the way to prevent a denial is proof. And proof is in the form of medical documentation, medical support from your treating providers, and your policy provides that it's your duty to provide the proof. You can't rely upon the insurance company to gather the documentation and prove it to themselves that they have to pay you thousands of dollars per month. It's your duty to prove it to them, and never forget that. So always submit as much proof as possible.
Okay, so let's start with the first thing which you talked about was medical proof. And medical proof of disability comes about, I think, in two different forms. There's one that people kind of sit back and wait for the insurance company to ask for a attending physician statement claim form that has to be submitted. But you and I both know that that form is just one document, that really what's going on is the medical records behind the scene. So talk about the importance of medical records being properly documented, as well as treating with the appropriate medical specialist.
So doctors, they write their reports not to prove to a disability insurance company that somebody's disabled. They write the reports that treat the patient. And sometimes their reports are bare bones, just so they can go back next time you come to their office, see what happened last time, But they need to be more clear. And sometimes you have to talk to your doctor and explain to them what you're actually going through, that you actually are on a disability insurance claim. You might want to educate your doctor what it means to be disabled under the terms of the policy. More often than not, for the first 24 months, you have to prove to Lincoln that you are disabled from your own occupation. And after 24 months, you have to prove that you're disabled from any occupation. And it's important that your doctor knows what your occupation is, what the requirements of your job is, so that when your doctor writes those reports, he or she is writing restrictions, limitations that prove that you're unable to perform the duties of your own occupation or any occupation, and it can point to objective evidence of why your doctor feels that way. So like you said, you have to go beyond an attending physician statement. Half the time, I don't even believe they even review the attending physician statements unless it's something detrimental to your claim. But for the most part, the most important proof is your medical documentation. It's great to have your doctor's support in filling out the APS or writing a letter of support, but the most important thing is the medical documentation and the objective evidence behind it.
I think that the other thing that's important is making sure everything's in those records. You know now that medical records are required to all be digital, which means that they're electronically typed. We don't have the days anymore of the handwritten records, but with that comes some downsides because the medical records in front of the doctor pulls up on the system, and a lot of it form fills from the last visit. Right. And very often we see that the same, if it's something that's not favorable for a claimant, is carrying forward to the next time. Like for example, someone who has back pain, and then it will say like musculoskeletal limitations, and it might say, possible limited range of motion, but no soreness.
Right.
No spasm.
And it says that for 3 months in a row.
Right.
They use it against you, sure.
When the claimant's like, what do you mean? Every time I'm going in there, my back's in spasm and it's hurting me. But the doctor, not intentionally, is forgetting to update the record. So I think that's essential, and the claimants need to be aware of that, so much so that I think claimants should be saying to the doctor, can I take a look at the medical records like right after the visit or within a day or two to get them, review your records, and make sure everything that you want as a claimant is in there. The other thing that we do with our claimants when we're representing them is to say, keep a log of your symptoms. And so much so that if it's a daily log, and we provide a free one on our website, kind of what we call a daily pain log that you can download and keep that, but it's also just as simple as taking a calendar and writing down how you're feeling, if you have a flare during the day, what parts of your body are bothering you, if you're fatigued, any of your symptoms. And then taking that log and giving it to the doctor. I mean, how often do you have clients that you say, go ahead, take this log and make the doctor include it in the medical records?
It's very helpful.
Because what happens is that means the doctor, even if the doctor doesn't document it appropriately, at least the symptoms of the claim are in the records. Because what do you get from in denial letters about symptoms versus the medical records? What do you commonly see?
Well, they take a little thing in the medical records and they run with it, and it says, oh, today he felt a little bit stronger today, felt a little bit better, the pain was not so bad. Like you said, the doctor leaves those same records and repeats them for 3 months in a row, and it says, oh, each time you're reporting, your pain's getting better, and they end up using that against you and denying your claim. So what Greg is explaining is very important, that your symptomology is in there, because sometimes your symptomology, there's no objective evidence to prove a level of pain that you're suffering from. But if it's in there and you're reporting on a consistent basis, each time you're bringing with you one of these pain logs and telling your doctor exactly how bad you are feeling or what you are feeling, and it's in those records, the insurance company, is one less thing they can harp on for trying to deny the claim.
The other thing is doctors don't want to be like always writing negative, and they want to put in the positive things that a claimant tells them. So the claimant, someone who's sick going to see their doctor would love to say, yeah, I felt a little better. From my experience, if they have any improvement whatsoever, then the disability carrier is like, well, you're getting better, so maybe you're ready to go to work. Right. So it's like this double-edged sword. You want to go and you want to have better, and you have some good days and you have some bad days, and the doctor doesn't always want to document the negative. He wants to try to show the improvements.
But he's treating you. I mean, he's getting paid to treat you. So.
Right. And so the doctors tend to lean towards putting in the positive type findings and not necessarily the negative, and unfortunately the companies know that. And Lincoln Financial takes advantage of that and uses the positive finding of the doctor to say, you're better, let's start talking about you going back to work. Right. How important is it when you're treating when the doctors suggest that you go for some additional testing of some sort, diagnostic, and the claimant doesn't do it? Do you see that could have a negative effect on remaining on claim?
Of course, they want to use everything they possibly can against you. If they're asking you to go do a functional capacity evaluation, or maybe not even forcing you to do one, but recommending that you do one, or any other objective testing, you should do it, because they're going to use it against you and say, we brought up this, that, and the other, and you decided not to do it, and based on our review of the medical records, which might be weak, they deny your claim. So it's best to do as much as possible. I always recommend, if you're suffering from a physical condition, to do a functional capacity evaluation to show your occupational abilities and inabilities. If your job is a light duty job or a heavy duty job, you want to prove that you can't do that level of strenuous work. If it's a sedentary job, you want to prove that you can't do a sedentary job. And it's always good to have those records in your file. You don't even have to submit it the day you receive the report. You always want to have a backlog of medical records ready to go as soon as the insurance company starts inquiring about such.
Okay, so you brought up, when you were talking, it made me think about another situation that commonly leads to a denial with Lincoln Financial, which is the change of definition. And you mentioned that, I think, in the beginning of the video, how it goes from an own occupation to an any occupation. When should a claimant start to be making sure that their file is in good shape so that they get through that transition period?
Well, you need to start 12 to 9 months before that change in definition of disability. I've seen insurance companies deny people claims due to the change in definition of disability, which is the most likely time they're going to deny your claim once you're approved. But I've seen them deny it 6 to 9 months ahead of that change in definition of disability, which kind of makes no sense to me whatsoever, because how could they predict that you're still going to be disabled, that you're not going to get worse in the next 6 months? So it kind of messes with my head whenever I see a denial that way. But at the very least, it gives you time. If they deny you 6 months in advance, at least they know they're going to pay you for those final 6 months, and it gives you time to strengthen your file. If they don't deny you 6 months in advance, you have to know that a denial might be coming, and it's your duty to use that time period to strengthen your file as much as possible. You can't just sit by the wayside, wait for them to ask for updated records. You really have to go out to your doctors, get updated medical records, updated treatment, updated testing to prove this new definition of disability. Because again, this is when they're going to deny your claim. If they're going to deny your claim I'd have to say 90% chance this is the time period they're going to do it.
And what's challenging about that with Lincoln Financial in particular is that they require 2 appeals.
Right.
Now, what we're going to see in the transition is since Lincoln acquired Liberty, Liberty policies don't require 2 appeals, but the Lincoln policies do. On the newer policies that are going to come out over the next couple of years, I don't know if they will, but with 2 appeals, it's that much longer potentially that you have to wait.
And you're without benefits for a long period of time.
So that's if you get denied. The other topic I want to talk about is when we're handling a claim for a client, all communications come to our office, and Lincoln can't call the claimant at all, can't show up at their door to interview them. Nothing is done outside of our presence. Every letter sent to us, claimant never has to worry about, do they want something? Why didn't I hear from them? Because if they don't call us, and the claimant doesn't have to do anything. So that's a peace of mind that a lot of claimants really like when we're involved with the claim. But if a claimant is on their own and they get a phone call from Liberty or Lincoln wants to send somebody to interview them, how cautious should they be for that type of interview or in-person examination?
Very cautious. I mean, they're allowed to have you seen by a medical provider or an investigator or a person they hire of their choosing, as long as it's over a reasonable time period. They can't do it, once a week for 52 weeks, but every few months or every couple of years they can certainly do it. They're not doing this investigation to just make sure everything's all rosy. Any information they're getting out of this, they want to utilize it to deny your claim. So you have to be very, very, not scared, but obviously very prepared and understand what the purpose of this interview is. I mean, always call us if you have any questions. We'll always give a free consultation, maybe walk you through what to expect. Or you could actually hire us, and we can either be there in person, or at the very least, if it's the last second thing, be there on the phone just to make sure anything they're asking, any questions, or what they might be doing is all on the up and up.
And the other thing is, before they do these interviews, they've done extensive background checks, they've likely run video surveillance, so they're going to start asking you questions about specific things going on in your life that you had no idea they even knew about. They're running your credit history, depending upon how you completed the authorization for them. So you really, really need to be prepared, and you don't want to get stuck misrepresenting something, exaggerating something, or not answering appropriately, because you can avoid these denials by doing things the right way and not even having to be nervous about whether or not you're answering something or not. And we always prepare our clients extensively for these interviews. And often if we're involved, they won't even speak to the claimant, they'll just speak to us, and we'll relay whatever information it is that they need. The last area I want to talk about is on the claim forms, and not the attending physician statements, but the regular claim forms that come. I find that they're wholly inadequate for the information that's needed. Talk about why you always do an addendum on these claimant statements, whether they're requested monthly, quarterly, or semi-annually by Lincoln.
I mean, these forms, they're not written specifically for your claim. They're just essentially the same forms that are shipped out to thousands of people across the country. And not everyone fits in a square box. So when they ask certain questions, you might have to expand on it, or you might have to write your own explanation of what's going on in your life or what's going on with your various conditions. Because again, nothing fits in a perfect box. Every single claim is at least a little bit different, if not a lot different. So you really have to expand and essentially prove to them continually why you're disabled and go above and beyond what they're asking. If you just answer yes or no and check some boxes and fill out I can't work because pain, they're going to deny your claim. You really have to go above and beyond what they're asking and give them more information than they possibly want to know. Give them all your medical records, all your medication lists, all your treating providers. You have to get as much proof to them as you possibly can.
And I think also important the manner in which we answer the questions for what activities are you doing? Because a lot of people get nervous with that question. They want to say, oh, I'm home and I'm in bed. Well, if you are really home and in bed all day, that's not the common situation for someone with disability, because you're allowed to have a normal life and do normal things. But you have to know how to portray that in such a manner so that you don't have to worry. And that's the pressure that we want to take off the claimant, is live your normal life within reason, have a disclosure that's appropriate with Lincoln so that you don't have to always be looking over your shoulder and saying, oh my gosh, am I doing something that's going to result in a denial? And that's the kind of foundation that we want to set up for a Lincoln claimant and maintain for them. and at the same time work with their treating doctors to support these other activities they're doing. I'm not saying they're going to be able to go and do every single thing they want to do within reason, but you have to know that delicate balance so that you can protect yourself, enjoy your life, and at the same time not be completely paranoid that your benefits are going to be denied.
Right. I understand why people are paranoid and want to describe their restrictions, limitations worse than they are, or say that on a daily basis maybe I leave my house for 1 hour a day. But they're going to catch you on surveillance, being at the mall for 2 hours, and there's nothing illegal, there's nothing improper about, like Greg is saying, going out and living your life and going shopping or going to the supermarket. You have to be able to do those things. That doesn't mean that you can work 40 hours a week at whatever your prior job was. It's just because today you went out to the supermarket for 2 hours and did all your grocery shopping for the month, doesn't mean that tomorrow you're not down for the count because you strained the heck out of yourself the day before. So sometimes it's better to be honest. Obviously we have to figure out there's a certain level of communication. We don't want to give them too much information that they're not asking, but there's a level that you can give them and safely feel that you can give them this information. Sometimes it's worse to get caught in I'm not saying that you're lying, but something that could look like a lie or you're being misleading.
Terrible. So in summary, what we do for when we help someone with a claim is we offer basically a flat fee type arrangement that's very affordable based upon the amount of your monthly benefit, the amount of time you have left on your claim. A lot of claimants love that arrangement that we have because we basically become vested in your claim and we don't get paid unless you get paid. So we have a strong vested interest to make sure your benefits continue so that you can continue doing what you're doing, and we take the pressure of dealing with the claim. All of our clients are spread all over the country. We're available to offer you a free consultation at any time. We'll simply ask for a copy of your disability policy. Whether you call Alex, myself, or any of our other disability attorneys, we're always going to provide you with an immediate free consultation, and we look forward to the opportunity to speak with you.